Hi, I'm Keith Davidson at Albertson and Davidson, and today I want to talk to you about the evidence that you're going to need if you're going to prove a lack of capacity. So one way we overturn trusts and wills is we try to say that the decedent had a lack of capacity. But under California law, it actually spells out the type of evidence that we need to bring into court in order to prove that lack of capacity. And the bottom line is we have got to show a mental defect. So you're never going to be able to prove a lack of capacity without first proving that there was a mental defect. That means that there was something wrong, obviously, with somebody's mental state that affected things like their alertness, their thought process, their ability to modulate their mood. It's all spelled out in Probate Code Section 811. And typically what we have to do is hire an expert witness to come in and testify for us as to the state of mind of the decedent and to prove that that mental defect was there. And the most common one that you find, of course, is things like dementia and Alzheimer's. Those are a classic example of somebody having a mental defect. But there could be others. So if somebody was in a car accident that created some sort of a mental defect, that would work too. The second part is that mental defect, it actually has to somehow affect the capacity standard. So for example, in order to make a will, there's three things that somebody has to know in order to have capacity. So they have to know that they're creating a will, they have to know who their children are, the people who are going to benefit from the will, and they have to know the nature of their property. So what we have to prove if we're going to prove lack of capacity is you have to show that that mental defect somehow made it impossible for them to understand one of those three things. So because of the dementia, they couldn't understand the nature of the property. Or because of the dementia, they couldn't understand their relationships, like their children. Or they couldn't understand that they were creating a will. So there has to be that correlation between the defect and the standard that you're applying. And once you have all of that, then you have sufficient evidence to be able to prove a lack of capacity in court.